think being the next of kin means you inherit everything? Think again. Let's talk about that. If you live in Georgia and you rely upon blood relations as your legal shield, this is one of the most dangerous assumptions you can make. And one of the most common things I run into as a probate real estate specialist is people think, well, I'm their child, so naturally the house and the bank accounts, they'll all come to me. Here's the reality. Georgia law gives zero priority to blood relations over a stack of legal mechanisms that sit directly in front of you. And today we are going to walk through the 5 separate legal forces in Georgia that jump completely ahead of the next of kin. And one of them can take the family home before you even touch that key. Let me show you how this actually works. Number 1 is the force that catches families off guard when it hurts the most. This has to do with title and deed overrides. When a loved one passes away, everybody assumes that the estate, the bank accounts, and the investments drop into the estate and will be passed on to the family. And that is only true if those assets are held in that person's individual name alone. If a property is held under joint tenancy with rights of survivorship, or an account has a designated beneficiary, like on a transfer upon death deed or a payable on death tag for a bank account, it never touches probate. It bypasses right by probate. It doesn't matter if you are a biological child or not. Whoever that beneficiary is going to get it. And it doesn't matter if your family lived in that house for 40 years. It doesn't even matter if your parent pulled you aside and said, hey, I want you to have this house. The deed's legal contract overrides blood relatives every single time. And if you're looking for the house keys, but legally you don't even have the right to open that door. And this is what my husband, Tom, calls a last man standing inheritance. And this can cause serious trouble for blended families. You could have where your parent remarries and they pass away. You're expecting to get some kind of inheritance out of it. But if they have that deed where it's with rights of survivorship, it automatically goes to the step parent. And, that's the person that is the last man standing or woman. Force number 2 is a legal mechanism that's almost unique to Georgia, and that's years support under Georgia Code Section 53-3-1. A surviving spouse and minor children have the right to petition the probate court to set aside a portion or even all of the estate assets for their maintenance and support for the next 12 months. So why is this such a massive deal? Well, because your support is considered an expense of the administration. And in Georgia, that takes priority over all other estate debts and claims and completely skips the adult children. Imagine a scenario where an adult child expects to inherit a portion of their deceased parent's home. And if the surviving spouse files a petition for years support and asks the judge to award them the entire house to live in for the year the court approves it, that property, is being used up by the spouse for a whole year. Depending on how much money is involved, the adult child who's considered next of kin could get nothing from that asset. Years support skips unsecured creditors, it skips adult heirs, and it completely rewrites who gets what from an estate. Number 3, Georgia is a strict debt first state. There is a widespread myth that if a parent or a relative passes away, that their cash and personal property immediately belongs to the children. And people, they actually start going through the house and they start splitting up the furniture and they try to access the bank accounts. And when you really look at the statutory list, the next of kin sits at the bottom of that list. Before a single dollar reaches an heir, the estate must publish a notice to debtors and creditors and wait out the statutory notice period. Funeral expenses, medical bills, credit card debt, personal loans, and estate taxes all get paid first. So if you have a $300,000 estate and it has $300,000 worth of debt, the debt takes everything, and the next of kin inherits 0. Number 4 comes into play when somebody dies intestate, meaning without a valid will. So we're going to talk about if someone dies in Georgia without a will, leaving the spouse and the children. Georgia law is split under O.C.G.A. 53-2-1. The only thing that can change that is if the house is deeded a certain way, like we spoke of earlier, or if the bank accounts mention a particular beneficiary. So if they didn't do that, under this rule, the spouse gets a portion with the children, but the spouse share cannot be less than 1/3. So therefore the kids would get 2/3 and split it amongst themselves evenly. And without a will, the estate is intestate and dictates by this statute percentages, regardless of who needs the money or what the family was promised verbally. And if there's minors involved, then the court gets involved fast, and all of a sudden now you have a guardian to have to deal with on top of everything. Now, I've actually seen this play out in real life. A family had a property where the deed was set up with tenants in common, so that verbiage with rights of survivorship was nowhere to be found. They didn't have a will, and the mom inherited 1/3 of the dad's portion of the estate, and the children inherited 2/3 split amongst them. Now, luckily, these children were nice. They were adult children, and they gave back their portions to their mom so that she could have money to live out the remaining part of her life. But by law, she didn't automatically own the home outright. She owned a portion of it, but not the whole thing. And finally, number 5, express disinheritance. Unlike several other countries or even some U.S. territories, Georgia law does not require parents to leave any portion of their estate to any children. You have no statutory right to inheritance in Georgia simply because you share DNA. And if a person executes a valid Georgia will and includes a clear disinheritance clause stating explicitly that they leave nothing to a child or to a parent or to siblings, depending on how their inheritance is, that sentence overrides blood entirely. And unless you can legally prove the lack of mental capacity or that someone was under influence of fraud when signing that document, Georgia probate courts will enforce the will as written. Blood relations gives you a standing to be notified, and that's it. It does not guarantee you a dime. This also goes for whether or not your name is an executor. I've seen some wills where somebody thought that they should be the one running the show, but the person who passed away named a different executor. So they try to go in and act as if they're the executor simply because they're next of kin or simply because they're the oldest. And maybe their parent named a younger child, but they don't think it's fair. And yet the will explicitly states that they are not the executor. So when you stack up these 5 forces together, the picture becomes clear. Proximity does not equal priority in Georgia estate law. Titles and deeds bypass probate completely. Your support can override creditors and adult heirs. Creditors get paid before the family sees a dollar. Intestate laws force unexpected asset splits. And a simple will can disinherit to the next of kin entirely. So I hope this video helped clear up any confusion. And obviously, we're not attorneys, and this is not legal advice. So if you need a good attorney for legal advice, I can connect you to somebody who can help. Otherwise, be sure to hit the like button, subscribe to our channel, leave a comment below. And if you like this video, stick around. You might like this next video. And I'll see y'all later. Bye.